So, U.S. immigration attorney Sharifa Tharpe. I'm here live to take your U.S. immigration related questions. Go ahead and put your questions in the comments now so that I may answer your questions. So, I have a good topic for you today. It's going, as I promised, going from the 2-year green card to the 10-year green card. What's that all about? And this is a good topic, even if you don't have your green card yet, because this is something that you may need to go through in the future. And so it's good to know ahead of time what this is all about. So you get a 2-year permanent residence when you get married to a US citizen or a legal permanent resident. And at the time that you get your green card approval, if you're married for less than 2 years, so 2 years or less, you will get the 2-year green card. If you're married for more than 2 years, then you get the 10-year green card and you get to live happily ever after and go on to citizenship. However, when you have the 2-year green card, you get that 2-year green card, it's like you're going through a probationary period. So that green card is sort of like a probationary green card. And the main purpose for that is that you are getting it for them to make sure that your marriage is bona fide, that is real. Yes, you had to prove that, or you had to show that in when you were getting the 2-year green card, but they still want to just put you through this probationary period to make sure that that everything is still real, that you are, even after going through the next 2 years, you're still in a bona fide marriage with your spouse. Now, what happens when it's time to get a 10-year green card, right? It's called removal of conditions, right? So even though I will sometimes use the term renewing your 2-year to the 10-year, the terminology that you will see on the form or in any instructions will be you'll need to remove the conditions on your 2-year green card in order to get the 10-year green card. And so it's called the removal of conditions process. And you have to file a special form called the I-751 form. Now, the tricky part about this form for some people is that you have to file this jointly with your spouse. That means that it's like the two of you are applying together. So even previously, when you applied for the green card initially, you had to sign one form, your spouse had to sign another form, but in this case, it's one form that the both of you have to jointly file. And it's because they want the both of you to say that your marriage is still real and for the both of you to show that. So you're going to have to show the same types of evidence that you did previously when you were getting the 2-year green card. You do have to show that. But one mistake that people make when they're applying is they take the same evidence that they sent in for the original green card. They put that same evidence in the new application to remove the conditions from the green card. That's a no-no. What they want to see is updated evidence. They want an update on what has happened in the 2 years since you got your green card. And so you're going to have to show them evidence, updated evidence showing maybe that you continue to have a joint bank account, that you've maybe started a family, so you maybe have now, or if you don't have children, maybe you have bought a house together, maybe you've moved a couple times and you have multiple joint leases to show now, that you're still together, still living in harmony. You may meet more friends and family, or the same friends and family that now can give an update on what they've observed on your relationship, your marriage together. And so keep in mind that that evidence should have the dates after you got your 2-year green card. No date should really be before you got the green card, but after. That's going to be very important. Now, One thing to note here is it's important to create a solid application from the get-go. Don't do this. This is a number one, another mistake that I see people make. They're like, oh, we're just going to hurry up and file this application and we'll give them whatever evidence they ask for later, or we'll do it at the interview. Don't count on an interview happening. Don't count on them asking for any additional information. Just do it right the first time around. The advantage of this is that if you do it right the first time around, you may not even be scheduled for an interview. You may just get your brand new 10-year green card in the mail. So do it right from the first time. Get all the details right. Put all the evidence that you need to in that initial application. Give them everything they're asking for in the initial application, so you could possibly get your interview waived. Now that this is what they're doing overall, they're waiving a lot of the green card, the interviews for the green cards, but where they're waiving it is where it's so the application is so thorough that they really don't have any additional questions. They are convinced that you qualify and they issue the green card. Now, what another thing I deal with as an attorney is where the spouses are now separated. The spouses either jointly filed together, but now the citizen or resident spouse is no longer in the picture. They left, or you're separated, or they filed for divorce, or you're divorced, and you have your papers pending. What do you do in a situation like that? Another mistake people make is they give up, right? They decide not to go ahead and pursue. They start to talk crazy, like they're going to leave their life in America and go back home because now their spouse is no longer in it with them. That means they can't get the 10-year green card. Not true. And if your spouse is telling you that you can't get the 10-year green card without them, uh, that's not true, right? If you do end up getting divorced, or this spouse, the US citizen or resident spouse, mistreated you under VAWA, which you hear me talking about a lot, this is also covered under VAWA. If they're being mistreated, the spouse, the immigrant spouse, can still go for their 10-year green card without that resident or citizen spouse. You don't officially have to be divorced. You could either be divorced, or um, you could be divorced or separated. So even if you're separated but you didn't get an official divorce, but there's mistreatment involved, you can go ahead and get your 10-year green card without that spouse. If you're divorced, but say there's no mistreatment, things happen, marriages sometimes don't work out. And so say you got divorced, can you still move forward without the spouse that you're now divorced from? Absolutely. Now, there are waivers available for these situations. The first is the divorce waiver. And in that case, you still do have to show that, despite the divorce, you enter the marriage in good faith and the marriage was real. You still do have to show that along with the divorce decree, proof of termination of the marriage. The other is if you're separated or you're still married, you may even still be living with the spouse, but they're mistreating you and you apply on your own. You have to still show that you enter the marriage in good faith, the marriage is real. You don't have to show that you officially terminated the marriage, because that one falls under FAWA. Now there are two other waivers. One is extreme hardship. So in the case of extreme hardship, what kind of extreme hardship? This extreme hardship usually means more than the normal types of hardship will you experience if you have to go back home. In this case, you don't necessarily have to show that the marriage was bona fide. You don't have to show mistreatment, but you do have to show that you will experience extreme hardship that is more than the ordinary hardship, right? So, for example, if you say, I won't have a job when I go back home, that's not going to be enough. It has to, and in addition to that, it has to be an extreme hardship that has developed in the last 2 years, right? So it can't be something that has been ongoing even before you got the green card. It has to be some change of circumstances in the last 2 years since you got your green card will now cause you an extreme hardship. So, for example, if you now have an entire family here, you didn't have one, but now you had the spouse, and you're unable to go back because maybe you have a special needs child, or maybe your children have special needs that if you can't take them back, or the fact that they're citizens and there may be language and cultural barriers and challenges to your family, your children, then that could serve as a possible extreme hardship. If you've gotten an education here, or if you're in the middle of getting an education and you started to get your education, so you're working on a degree in the past 2 years, that could possibly serve as an extreme hardship as well. Especially where it's you can't pursue the same type of education in your home country. So that's another one. The last one is if the spouse passes away. You do still have to show that the marriage was real and that you have to prove the death of the spouse. But that is also counts as a type of waiver you can show to get the tenure without the spouse. So if the spouse passes, uh, that should not be something that you panic about. It is doable to still get your tenure green card. And when I say panic, I know you're going through the grief of facing the death of a spouse. You don't need to necessarily panic over the immigration, because that can with. And we do help our clients to get through these complicated scenarios. Even if you're already in the middle of the process, we have taken cases in the middle of the process and we've turned them around for our clients, where the spouse disappeared, or the spouse was mistreating them, or the spouse got divorced from them. We were still able to turn their case around. So it is possible to get the 10-year green card without your spouse. So that is what I have for you today. All right. So if you would like legal advice, you would like representation, go ahead, click on the link in the description of the video on Facebook, on Instagram, and Twitch, and you'll see everything you need to get in touch with us to schedule that consultation. On Instagram, go to the link in the profile, and you'll have it there as well. Now I'm going to go ahead and answer questions. And before I jump into the questions, I will not be on live tomorrow because it is it's Easter, right? It's the Easter. So I won't be live tomorrow, but we'll be releasing videos that are informative and may be of interest to you. So go ahead, follow me, like, subscribe, so that others can see this information. And I will be back on Monday. So let's jump to questions. I received my prima facie after 5 months of filing forward with adjustment of status. How long does it take to get the EAD? About 6 months to 12 months after filing is when you'll get the EAD. Keep in mind the EAD is only if you actually filed a work permit application, employment authorization application. How long it take to get the receipt to show that the filing starts? It depends on the type of application. So for employment based and marriage or family based, you could see it instantly if you file online. By the way, if you file a petition online, you could see it within 5 minutes. If you do it paper, because some are not available online, you could see it with anywhere from a week to 4 weeks. VAWA right now, VAWA, humanitarian receipt notices, asylum, those are taking a little longer. So we're seeing receipt notices coming up to 2 months after the filing. All right, go ahead, put your questions in the comments so that I can answer. Okay, hi there, good day. I have a question. If I am a green card holder, can my husband visit me on a B1, B2, then adjust his status? That's a possibility. Now, keep in mind your spouse shouldn't be coming to the US in order to apply for adjustment of status. That is not permitted. However, if your spouse visits you on a B1, B2, and you decide to adjust status afterwards, sure, it is possible. Now, when you are a green card holder and your spouse is doing that, they have to make sure that they apply for adjustment of status before their time expires. And you also have to be mindful of the 90-day rule, right? The 90-day rule says that if you get married, if you work, or if so marriage, if you start working or file any papers within the 90 days of your entry into the US, they can assume that you had immigrant intent with a visa. And so, to be on the safe side, after the 90 days is also filing after the 90 days should also be something that you keep in mind. Now, if you have a stay of 6 months, then that may not be an issue. But if they give shorter than the 3 months, then it could be an issue for adjustment of status, and there are risks associated with that. But those are moves that you would have to make when your spouse visits, and you can make a decision there as to what your next steps will be as spouses. All right. Good afternoon. If you did a petition work permit and agree ending, how long will it take, and is there going to be an interview? They're waiving interviews in some instances to speed up the processing. However, how long it's going to take, it's remember that the green card process is not a one size fits all. There are different green card processes: employment, marriage based, family based, humanitarian based. And so, what kind of green card process are you going through? That's going to tell the processing times. But here's another way you can find out processing times. Go to uscis.gov, scroll down to case processing times, and you'll find their processing times at the service center there. They do give a range of time that's taking to process applications. If I'm approved for Form I-130, can I apply for my Social Security and work permit before I have a green card? Now, if you're approved for the I-130, that alone cannot determine whether you're eligible to apply for adjustment of status to get Social Security and the work permit. The I-130 petition alone does not get you your green card. In order, unless you have to then go to, if you're outside of the country, you have to go to the embassy, go to the interview, get the immigrant visa to travel here to become a permanent resident. If you're in the United States, your case isn't gonna go anywhere until you file for adjustment of status. When you file for adjustment of status, that's what's going to get you the work permit and social security number. But you also have to determine whether you qualify for adjustment of status, because some individuals, even after an overstay, you're still able to apply for adjustment of status with an approved I-130. But other individuals do have to wait for their priority date to be current. And then there's also the question about whether you're in status currently or you're out of status. If you're out of status and you are not the immediate relative of a US citizen, then that means that you may have a problem filing for adjustment of status. So, this is where the consultation is very, very important, because whether you can apply for the work permit and social security number through adjustment of status is going to come down to a lot more follow-up questions to determine your eligibility. So go ahead, go to the link in the profile, click on the link, and we can definitely advise you there. Let's see. So my mom's filing was refused based on a fight she had before I was born that she wasn't convicted or arrested for. Can she apply for a visa? It's been 5 years now since the refusal. So I'm thinking this is a visa refusal. This is more complex, and usually I'm not sure how, if there was no conviction, how is it that this no arrest, no conviction, how is it that this became an issue? And was she charged with any other immigration violations? Was your mom, did she enter the United States and get refused at the border? So it comes down to a lot of, this would require a lot of follow-up questions. So I see visitor's visa. She can apply and refuse. I'm thinking 5 years. She was turned around at the border for expedited removal. It sounds like. Um, so if she was turned around at the border for expedited removal, then usually there's a 5-year bar to that. And even after the 5 years, there's no guarantee she would be approved for a visa, just because the United States, they're not easy to forget past issues in an application. And they also will have to look at other factors like, um, so her daughter filed for her. So Gracia, this is a lot more complex. So go ahead. This is definitely requires a consultation, just because if if her daughter filed for her, she was refused a visa, there was a fight, that she wasn't arrested for or convicted. So I'd have to understand fully what's going on here, to be able to advise on the consequences. Um, All right, so I don't see any more questions, so I am going to go ahead and head out. Um, Now, I will not be on tomorrow, so I will be back on Friday, on Monday. Keep in mind that if you would like to go ahead and schedule your appointment, you can do that even while the office is closed. Go ahead, and we do have a call line that's 24/7. So even if you need to call, get in touch with us, you can call the call center. They will be more than happy to assist you, and then a scheduling coordinator will get back to you the same day. So thanks everyone for joining me. Thanks for your questions. I will be back on Monday. Friday, I'm out because it's Easter. It's Easter holiday, so I am out. Have a happy Easter weekend, and I'll see you on Monday. Bye bye.